been an interesting week for others. And thinking about
Ready?
second
Okay.
chances and
Good morning, everybody. It's a little after 10:30, and this is the final meeting of the Moral Character Working Group. Thank you all. We're here today. We have one person, Meredith, who's on the phone, and a couple who couldn't make it today, but we've been communicating, or staff's been communicating with them. So again, welcome. The next item on the chair's report or session is a call for public comments. I do understand there will be someone here later today who would like to make public comments, and if it works, I'll probably call for public comments again later. But for right now, is there anyone who wants to make public comments? Seeing no one.
he's actually on the phone right now.
Oh, sorry, do we have someone on the phone who wants to make a public comment?
Mr. Wexler?
Not at this point. I'm just listening in.
Okay, but you want to make one a little later, as I understand. Is that correct?
I may. I wanted to listen in and find out what you guys are doing.
Okay, thank you, Mr. Baxter. Okay, moving on to number 2, business. The first item is to review and approve the proposed best practices for law schools. Everyone should have that document. Hopefully it was showed over this morning. I had some comments, but I thought I'd throw it out to the committee and see what anyone has any comments about what we've been shown so far.
Yeah, this is Debbie. My understanding from talking to attorneys who prepare formerly incarcerated people for admission is that they encourage students to begin collecting the information very far in advance, which I note that you put on the first page. They also encourage students to put together a personal statement. Is that something that you think would be applicable to all applicants, and or that something that we suggest be included? And I'm sure David and Tara, you've seen these personal statements that these applicants have put together. But I'm just wondering if it's something, I know those who get counsel probably get advice to do that, but I'm considering the person who doesn't have the funds or doesn't find pro bono counsel, like if we're trying to position people to be in the best possible place for admission.
I think that'd be actually a great place to put it in here as well. We're working on the FAQs. I think we've mentioned it a couple of times, and that's something we have on there. So I don't see any reason why we couldn't add that.
So I thought maybe you have on page 2, providing information and documentation, maybe a bullet there. I didn't know if that's the appropriate place for something like that.
Is that something that would come with the narrative, like a Form 2?
Well, so when someone is disclosing a criminal history, the form itself asks for a narrative regarding the event, but it doesn't ask for what we typically call like a rehabilitative narrative, and that's what the FAQs are asking for. So I think what we could say is, because some applicants think, well, if it's not on the application, I think then I shouldn't submit it now or I can't. But so we can let them know that they're welcome to submit any additional narratives regarding rehabilitation or something like that at the initial time of submission.
Great. Thank you.
I have a question. How will this document be disseminated to the law schools? Is it something that's going to be on a website? I'm thinking probably not. Or is it a paper that will be sent through mail sometime soon? What is the plan for that?
So I think the plan was to have Natalie bring this up at meetings for CS bars and law school council, and then kind of let the law schools decide how they'd like to receive it. I don't have the dates, I'm sorry, in front of me for the next meetings, but I think that was the plan going forward.
It's a good document. I like it.
Thank you.
So with respect to Debbie's comments, are you going to add some language? I wasn't clear on that. So.
Yes, so I'll do that right now, and then before we make the motion to approve it, we'll put it onto the desktop with the track changes. So.
Okay. With respect to the best practices, I had 2 particular additions I was going to suggest under general information and guidance. where it talks bullet point number 1, law schools report greatest consistency. At the end of the sentence, it says with questions related to moral character. I thought it'd be better to say with questions relating to the moral character determination process. It's not as cleaner, but that was just my thoughts on that one. The second one was, again, I've done a fair number of moral character formal conferences, and there were a couple of things that kind of jumped out with respect to applicants attending or saying they didn't really understand the process. So I had an additional language which Tara's going to add on a little later to look at that said that the student should repeatedly the school should repeatedly remind students that it is the applicant's responsibility to become aware of the moral character determination requirements, to read and understand the instructions, to update the application when changes occur, and to timely comply with all requests for further information. This kind of narrows down the things that we see, well, I used to see so often in formal conferences where they would say, well, I didn't read it, or I didn't understand it, I didn't update it, and I didn't understand I had to timely comply. And I think having the schools remind students of that is helpful. So I would recommend adding that language, but you guys can decide whether or not you want to do so. I believe our thought was we would go through the 3 different forms, and then at some point in time, Tara would put them on the board with the changes, and then we would have a motion to see if we wanted to approve them. So that's how I propose to proceed. Anybody else have any comments or suggestions on the best practices and talking points for law schools? Okay, moving on to bullet point 2B, moral character statements and guidelines. Again, you should have this in front of you. It's an 8-page document. Does anyone on the committee have any thoughts or comments back to the current version of the moral character statement and guidelines?
I do. As to page 6, unauthorized practice of law. First sentence, it says the unauthorized practice of law may include, but is not limited to, appearing in court or other tribunals, providing legal advice, and so on. I propose that after the word tribunals, in the second line, that we add the words, as a legal representative for others. Because certainly somebody appearing in a court or other tribunal in and of itself is not an unauthorized practice of law. They may be representing themselves. But if you add the words as a legal representative for others, that it conveys the thought that we all have in mind for sure.
Good point. It's a good point. Anyone else have any comments about that? Did you get that language?
Yep, I did. And then just, there's one suggestion staff made, it's just a correction for one word on page 3. At the first paragraph, the last sentence, it says if an extension application is not approved prior to the expiration date, it's supposed to be submitted. So we'll just make that one change.
I'm sorry, I didn't see where you are.
First, not full paragraph.
Okay.
On page 3 at the top, the final sentence there, if an extension application is not approved prior to the expiration date, the word approved should be submitted.
Yep.
That was just an error.
Then I think
I had a couple of questions and comments. One was just generally to remind folks that this comes from, that the standards come from, are derived from case law. I think it's important to, like, this isn't to remind the public and particularly applicants that some of the principles here come directly from what the court has told the State Bar they have to do. I think it would be helpful because then it's not like they think it's coming out of thin air or just what.
We're making it up ourselves.
You're making it up, yeah.
Yeah, and can I add that some of the concepts come directly from case law, and all of the concepts are constricted by case law.
Right,
In other words, consistent with, I guess.
right. So I just think it might be helpful somewhere to put that up front so that it's clear. It didn't necessarily have language or tell you where to put it, but. And then my second comment related to page 6 of the document. Is it page 6 or page 5?
I think it's
Page 5.
5.
Yeah, so I had emailed David and Ezra about this, just the language about criminal history. I wondered where it came from. I recognize the language from the previous, from the website. I know that that's the language that's up there now, but wondering whether or not there's a way to frame it so that it more accurately reflects what case law requires. Because I felt like it might right now have a deterrent effect on anyone who has these felonies from applying.
Yeah, I think, you know, Debbie and I discussed this a little bit, and the idea is, I mean, it does reflect case law, but it sort of comes across as more of a deterrent to people who have in their past serious acts of misconduct, rather than what it's intended to do is sort of caution that yes, serious acts of misconduct raise serious issues, but there is a rehabilitative process that one can go through. And so in a way it should be reassuring rather than deterring. And I have some idea of I have some proposed language if you all would like to hear it. Hastily, but this is all basically paraphrased from case law, including Gossage and Glass, and it would say something like, there is no criminal act that disqualifies an applicant from receiving a positive moral character determination given a sufficient showing of rehabilitation. Where serious misconduct occurs, positive inferences about the applicant's moral character are more difficult to draw, and negative character inferences are stronger and more reasonable. When there have been serious acts of moral turpitude, the applicant must demonstrate that he or she behaved in an exemplary fashion over a meaningful period of time. And my idea there, Debbie, is first to lead with the fact that nothing disqualifies, because that's the myth.
I think
That's
that's
much better.
yeah, no,
And then the following two sentences sort of repeat what's said here, but they more closely track the language from the cases.
that's fantastic. Thank you, David.
Sure, and we can. I don't know if you want to or did you describe how we're gonna?
Yes, so can you email that to me right now?
Yep, and we'll put it up on the screen, and then.
And then backing up for a moment to Debbie's other point, I think with saying that it came from the case law, David had proposed 2 versions of a sentence that we can add to the disclaimer in the matrix, but also I think we could add it to the statement and guidelines in the decision matrix section itself. So I don't know if you want to.
Oh yeah,
what you wrote.
let me do that. Okay. So, yeah, and I agree with Debbie here as well, that if you look at her point was that nowhere does it say that the idea here is to be consistent with the law. And where I thought that might be appropriate is in the disclaimer that appears at the bottom of each page. And I agree because it sort of leads with the decisional matrix reflects the methodology typically utilized by the State Bar of California, et cetera, which makes it sound like the State Bar of California just sort of, or might suggest that it just came up with these standards out of whole cloth, when of course they're all derived from and consistent with case law. So I was thinking that there could be a second sentence in the disclaimer. So the first one would remain the same. And then the second one would either say something like, the information in the matrix is consistent with decisional, statutory, and other relevant governing law. Or, another possibility, the matrix is intended to reflect standards set forth by the California Supreme Court and other governing law. And, you know, I mean, these are not, you all are not restricted to these choices. I just wrote those up, and I would definitely want Michael Glass from OCTC to weigh in perhaps on any final version of that. But I think that both of those capture the idea that the standards are derived from the law, but do not misrepresent the fact that every specific concept in the matrix is not literally, you know, coming from case law, because the court hasn't addressed some issues in that much detail. But in that case, those concepts are at least consistent with and restricted by the law. And if you'd like, I can email these to Tara. She can put them up on the screen, and people can do what you will with them. They can be changed.
David, would it be possible to include that also, or is it appropriate, I guess is the question, for that also, language like that to be included in the section of the moral character determination statement and guidelines under governing law?
Is that what you were thinking, Tara? I kind of, because I was sending you an email and you were saying where else we might put it.
I was thinking maybe under mission and purpose, because it really is, the purpose is to comply with California direction rather than under governing law. But either one would work.
Mhm.
I was thinking maybe when the process of making a moral character determination for those seeking admission and a license practice law shall be consistent with case law and statutory law, uniform, consistent, and transparent, or something like that. Throw it in that first sentence. I'm open to ideas. I'm just kind of throwing my thoughts out.
Well, I wondered if consistent in that sentence is supposed to be, I mean, it could be consistent with law, or it could be consistent one applicant to another, you know?
Yeah, like both consistencies.
Yeah, yeah.
And where was that spot, Jim? Oh, I see, yeah. That's,
Or it could be under governing law, I don't know.
Yeah.
I have sort of wondered about the use of those words uniform and consistent there. If they mean two different things. So maybe we could borrow the word consistent and apply it to the law.
Mm-hmm.
It seems like that would be a decent place
Mm-hmm.
for it to go, but that doesn't mean it couldn't also, well, I guess if it's there, that would do it.
I like it in the matrix. I think it should be in the matrix, but I think both places, you can tell more than less is always a better thing.
Okay, so rather than having the two sentences, they were saying put it in the first sentence.
Shall be uniform, consistent with standard, I don't know.
Somehow adding that in after the word consistent, and I'm not quite sure I have the answer.
How about shall be uniform, consistent with governing law, and that's it.
Do you think that's okay?
Yeah, I think if you have it in the matrix, that language that you have. I'm just wanting people to know that some of the restrictions, for lack of a better word, derive from case law that you're governed by, and that make it difficult for you, because we've talked about some ways in which we might have in a different universe had different standards, but that the few cases that we have restrict us.
Yeah.
That's all. And
The working group's choices were limited by the existing
and I
law.
think it's important to note that to applicants so that it may anticipate some
And then Jim, I believe you wanted to
So
add this.
on page 3, the same language I suggested we add to the best practices, I had suggested we put in after the first full paragraph, again, reminding the applicants it's their responsibility to become aware of the moral character determination requirements, to read and understand the instructions, update the application when changes occur, and to timely comply with all requests for further information. Back to Michael's question, though, is how is this going to be disseminated? Because this is somewhat different than the best practices.
Yes, so the statement and guidelines, this is going to take place on the website of, so currently it says moral character, and then there's 2 links, one is the statement and one is the factors. So the statement and guidelines and the matrices will all be available online. And then once we get to the implementation part, we're actually gonna have 2 folks from communications come onto the line with us in case there's any questions that we can't answer, since they are gonna help us with finding a graphic designer to look at it once we're done with the content of it today.
I assume they'll have a rollout strategy, right? Your communications folks?
I believe so. We haven't gotten that far yet. We started with how are we gonna look at the design, and then we started asking some questions on how it would be implemented on the website, and they said it's really contingent on how the design will look. So I think we had to take a step back from where our questions were going.
My suggestion is when we give best practices to the school, this one go to the school too. I think the school should hand these out physically to the students.
How many schools are in this? There's maybe 50 schools, right? Tops. So it's something that could be mailed to or emailed to pretty directly.
And we also have the quarterly law school newsletter now, so that's also information that we could put in there. So
And I assume the communications folks will also do a, press release and send it to all the legal newspapers. I mean, I would assume that that's typically what they do when you come up with a new policy, right?
And like, don't the student affairs, Meredith may know this, will know this. The student affairs deans, don't they gather, like they have a trade conference? So maybe presenting at something like
they
that?
have the law school assembly as well, where both the groups
Yeah.
come together. So that's why. So we're definitely going to incorporate it into those sessions that Natalie leads with her group to get the word out to the law schools. So.
Yeah, I mean, I'm sure they know what they're doing, the communications folks. They'll have a whole rollout plan. I used to do that kind of stuff, so media, social media, blah, 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 it's a whole package, and that gets it.
Okay, so is there anything further that we want to talk about with respect to the statements and guidelines at this point in time? Again, we'll look at them again before we make any final motions, but anything you want to add right now? Meredith? You still with us?
I don't have any additions, but I appreciate that my comments were taken into consideration once I sent last.
Thank you. Let's move on to 2C, approval of the moral character decisional matrix, which I think is now called the decision matrix.
There was a long decision-making process to decide whether it would be decisional or decision, and we defer, of course, to the working group. But
So this is a 10-page document. Hopefully you have it in front of you. I'll throw it out for comments. I've got some comments too, but does anyone else have any comments about any of these pages or any of the entries? Hearing nothing, I'll start with mine then. On page 1, conviction of drug sales and possession. I believe under the additional inquiry may be needed, initially we separated sales of drugs versus possession of drugs, and we said possession maybe that it'd be 2 and more, for sales it may be 1 or more. It now got contracted to just 1 or more convictions. Do we want to separate sales and possession as 2 different type of activities, or do we want to leave it 1 or more convictions, period? I just throw that out to you for comment.
And can I just add that I don't remember the exact history, but I think that may have been I remember thinking myself, and I don't know if it was my suggestion, that those two bullet points, the ones that were previously there, were redundant. But then upon rereading them, I realized that they're not redundant logically because they provide that, additional inquiry may be necessary if you have one or more sales. So that's one or more, and then,
I think it's the other way, if it was one,
oh,
Conviction for
see,
drug
it was even
sales.
before this version.
yeah, so I think those two got combined just while we were trying to clean up the text of it, but we certainly can break them back out again.
Yeah, it was one or more sales one sale and one or more possession. In other words,
Multiple possessions.
Right.
It's multiple possessions or one or more sales.
So if it's a single
thank
possession,
you.
you're saying it,
In other words, sales is more serious than possession.
But I just throw it out to you because I thought it was a change. And so if someone feels like it should be separated, then they should say something. If nobody does, then we'll move on.
This is Zach Wexler. I tend to think, in seeing different clients, that sales is definitely more serious than possessions, and I would prefer to see the matrix acknowledge that.
Okay, in the future, we'll wait for you to be able to make comments in public, but that's fine. Thank you very much.
I'm sorry.
No, that's okay. Debbie, did you have something you wanted to say?
I was just agreeing with you.
Agreeing with me. Okay, so again, we're not making a motion yet, but is it okay with the group if we ask Tara to say one or more sales convictions or multiple possession convictions?
Yes.
At least we'll put that on our proposal. We'll vote on it later. On page 2, on the mitigation, aggravation, and rehabilitation, I wonder under bullet point number 2, payment of fines, restitution, and other financial obligations, whether timely payment would make a difference. Payments timely versus not timely, or is that just being petty? So I throw that out there. If nobody else cares, I don't care.
I would say I would prefer for it not to be in there. The number of fines that a defendant can endure now is quite high. I mean, there's a lot of reform being discussed at the state legislature and in other jurisdictions about trying to pare back on all those. So I think it's difficult, particularly if someone's pretrial and is incarcerated, like how they pay those fines while they're incarcerated for periods of time. I think timeliness shouldn't be a factor.
Okay, I just want to bring it up. Anybody else have any thoughts? Michael?
I think even the way it's worded, timeliness could still be taken into consideration by those who are inquiring of an applicant. So I don't think it's a problem being worded the way that it is.
Okay, that's fine. Thank you. Larry, do you have anything? Okay. Next item I have was on page 4, again under mitigation, aggravation, and rehabilitation. The third to bottom bullet point says financial impact on victim. And I was going to propose we change financial and or emotional impact on victim, because there is an emotional factor here that I think is relevant. If it's very emotionally difficult to the victim, I think that needs to be taken into consideration. So again, I would suggest we say financial and or emotional impact on the victim, but I'm open to comments. Haven't heard anything, can we add that to our proposal, and then they can vote on it later?
And Jim, I'm sorry, can I jump in real quick? Just going back to the respect for and obedience to the law, there had been some discussion, and I think Judge Torrealba had brought up the idea of when moral turpitude is mentioned, to perhaps provide a link or somehow the list of crimes that California courts have held involve moral turpitude for the purpose of impeaching a witness. And we looked into that and in fact found that list. My concern about including it is that, and in fact the list itself says this at the top of it, that while there's a lot of overlap, the fact is the Supreme Court has held that moral turpitude in California, the definition of it depends on the context in which it's being used. And the court has specifically held that, well, let me see if I can find this actually. Moral turpitude in the context of using a felony conviction for impeachment is of limited relevance in attorney discipline proceedings. And elsewhere, the court has held that disciplinary proceedings are much like admissions proceedings, because they're both looking at whether an attorney is fit to be an attorney. And so that was so. I guess I do have a concern about including that list, just because there might be a few outlying examples there that don't really fit.
So instead, you're suggesting this footnote, number 1.
On page 1.
On page 1.
Yeah, it would. Yep. Yeah, it would be limited to that footnote, which is the court's most recent expression of the definition of moral turpitude in this context. Lazansky has since been positively cited, by courts of appeal. And essentially, the way Lazansky defines moral turpitude in this context is sort of two ways that moral turpitude can be involved. The first way is if the crime or misconduct involves acts that are specifically related to the duties of an attorney, so violation of fiduciary duty, misappropriation, things of that nature, violation of confidence. And so that seems fairly specific to the context. But then the second area is if the crime or misconduct involves, and this is sort of one of those definitions of moral turpitude that's a little bit question-begging. It involves such a serious breach of a duty owed to another or to society, or such a flagrant disrespect for the law or for societal norms that knowledge an attorney engaged in the misconduct would likely undermine public confidence in and respect for the legal profession. So that's the part where it leaves room for evolving societal norms. There are things in the past that society considered moral turpitude which no longer are. Anyway, so Lazansky, I think, is it is a accurate and decent reflection of the court's definition, and I would suggest leaving it at that.
I guess I would just come back to both of you who are, involved in conferences and making these determinations. Do you feel like that's enough guidance for you when you have an applicant in front of you? Sorry to do that, but I feel like.
Well, that's a hard. It depends on the
It's a big
situation.
sandwich to some extent. So.
Yeah, it is helpful in the sense that, like a lot of legal concepts, most of the factual scenarios fit fairly obviously into one category or another. There are outliers where one has to decide, but even when it comes to the sort of second category, just, something that offends societal norms, et cetera, even there, the court, there have been holdings in disciplinary cases, for example, that speak to very specific crimes. And so it can be helpful, it's helpful when it's helpful.
I guess I would just say, is it both helpful and also doesn't put everybody in that category?
Oh,
Anyone
sure.
who has a conviction
Absolutely.
is not someone who has a conviction involving moral turpitude.
For sure.
Okay, well
Yeah.
then it's helpful, right?
Yeah.
That would be the concern that I would have, is that you could argue that any conviction is a violation of societal norms.
Oh, right. Yeah.
Oh, I was just gonna say, and by the same token, if you do limit it to just certain felonies or certain specific crimes, that can create a false sense of security, because it is true, the definition in Lazansky is vague, but in my opinion, I think it's that way on purpose, so it can evolve as society evolves. So I think leaving the definition as is would probably be preferable, only because it does also put the applicants on notice that if your conduct, maybe it wasn't on the specific list, but it still could merit a finding of moral turpitude, depending upon, you know, when it was committed, how old the person was, etc. So, and the court will take all those factors into account in making that determination. In the disciplinary context, we call that the facts and circumstances surrounding the conviction.
And hopefully your comment, Debbie, about societal norms, hopefully the qualifying introductory phrases, a serious breach of a duty, such a flagrant disrespect for the law or for societal norms, at least suggests that it has to be, a violation of societal norms plus.
Just a simple conviction.
Yeah, it's like a special circumstance.
So this case, just to be clear, is a disciplinary case?
Yeah.
So is there a problem in using a disciplinary case as a standard, since the standards related to discipline are very different than the standards we use for admission?
No.
Okay.
I don't think so.
Because in other words, it's always been harder to get in than it is to get disbarred.
Well, so there are a bunch of cases.
No, it's the
true.
truth. There's different procedural standards. There's different standards that you use.
But the court has held in a number of different cases, and I wish I had these quotes at my fingertips, but that the standards for discipline and admissions actually are not that different, and particularly when it comes to moral turpitude. They've made comments like, these discipline cases and admissions cases aren't that different because they're both looking at the same issue, the conduct of the either applicant or attorney, and whether they have the moral character or the fitness, in the case of the attorney, to practice. So yeah, I think that it's safe to use a disciplinary case.
Okay.
The one thing I do want to say is I added that footnote and I see there are no quote marks, and I just want to ensure that that's not, if that's a direct quote, that I add those quote marks. But I'll look at that right now, so that's a minor little thing, but by the end of the meeting it'll be in the...
Since we're still on obedience for the law, I'm just wondering on the next page where it's mitigation, aggravation, and rehabilitation, it says one of the bullets is rehabilitation related to the offense. Is it more accurate to say rehabilitation related to the conduct underlying the offense or related to the offense? I don't know.
You mean because offense has it's a meaning of, it has a technical term in the law?
I'm just wondering that, so someone gets convicted of, let's say, shoplifting, but it's stemming from having an addiction. What you're really looking for is whether or not their addiction's been treated, right?
Right.
Not so much that, right? So it's
DUI.
conduct, right?
A DUI would be a good example too.
Right, so you're looking for conduct underlying the offense, I think. Is that, am I being...
I see what you mean, or maybe rehabilitation related to...
The conduct which resulted in the offense?
Yeah, something like that.
The problem with that, though, is we've done the past where we don't have finding that the conduct actually happened. The offense is found guilty of drunk driving, but the conduct may be alleged something else in the police report. You can't really convict or deny an applicant based on what the police say he did. It's only on what the court found he actually did, because we really aren't.
But
we
you're
try
more,
and
like, if someone's
find
convicted of larceny, like, what you're looking for is whether or not their rehabilitation is not just that they stop stealing, but also that they've addressed their addiction problem that would hopefully prevent them
Brought
from
about the
doing
larceny.
stealing in the future.
Yeah.
I
Yeah,
guess that's what I don't know, maybe I'm not being clear.
It's the brought about phrase you just used. I think that Debbie is after something like that as opposed to just related, related to, factors that contributed
Yeah,
to the
something like that.
misconduct, something like
Yeah.
that.
Yeah.
Maybe that's it. Maybe contributed is a good word.
Yeah, contributed to the offense.
Rehabilitation related to factors that contributed to rehabilitation related to misconduct that contributed to the offense, maybe.
I mean, factors is more broad, so if we're,
Okay.
I would lean towards that, I guess.
Thank you.
So what are rehabilitation related factors that contributed to the offense? Okay. Thoughts?
And if there's no other thoughts from the working group, I just had two things on the respect for and obedience to the law. So when we made the changes as staff, we didn't want to make any substantive changes. It was mostly just cleaning up the format and making sure it's not repetitive and things matched and whatnot. Two things we received from Donna that we wanted to just pose to the group. So one was, here it specifically calls out Prop 36. The question was if that's too narrow, if it should be more broad. The only caution I think that I would say is that since we've spoken about this before, is we don't want to just use the words dismissed and expunged, since depending on what statute and whatnot, they may still have to disclose but so that's one of the feedback, and the other was the wording on the contingent of the outcome of additional inquiry and whatnot. I know we didn't want to leave any of the boxes blank. David and I discussed it, and we didn't come up with an alternative, so we are still comfortable with that language, but we just wanted to bring it up that she was asking, is that informative enough for the applicants having that language repeated throughout the matrices?
I think it's fine. Regarding the first point though, I think it is useful to anticipate, just given how much reform is being undertaken in this area of law, that we leave open, that there might be a future Prop 36 that is going to come down the pike. So maybe having language that anticipates that, without it being so vague to just say dismissed and expunged. Right. Under state law.
Wasn't the concern that just under state law, it might be too broad? We wanted to say it had to be a particular type of dismissal or expungement that was really applicable.
I mean, it could say under Proposition 36 or a similar law, but then there's.
Like, what if they're coming from another jurisdiction? And it's been dismissed and sealed?
So there's the option for them to answer that they're submitting a statute in lieu of disclosing something, and then they provide the statute, and then David will review it. If it's sufficient, then that's fine, they don't have to disclose it, but sometimes it is insufficient, it does still require disclosure to licensing agencies.
Yeah, they'll submit the statute pursuant to which the expungement occurred. And then sometimes I'll look at the statute and paragraph G will say, you don't have to disclose any of this except to licensing agencies or a state bar or something.
Right.
Not often, usually it is correct that they don't need to provide any further info.
Do others have opinions on how you might gain that middle ground so that it's not only limited to Prop 36?
I'm just wondering if some wording can be put in to accommodate dismissals and expungements in other jurisdictions. It seems that we're limiting the comment regarding dismissal and expungement to California cases only.
Mm-hmm.
As are we in the felony conviction box above it when we say one conviction expunged pursuant to a statute listed in the conviction section of the application? The application itself has a long list of California statutes pursuant to which people can get matters sealed or dismissed. It's something to think about. My sense, for what it's worth, is that it's sort of necessarily going to reflect some California-specific issues, and in that case, the application itself does address the issue of out-of-state statutes, but we could somehow try to.
Could you put a footnote in? The way you did on the convictions involving moral turpitude?
Yeah, or even if it wasn't a footnote, maybe under the felony conviction at the end, after factors, adding the language that's something like the language that's in the application itself, or a similar statute from another jurisdiction, or something like that.
I like that.
So that would go under felony conviction and conviction for drug sales, since
Sure.
they're both.
Trying to just see what the language from the application is.
And I wonder if Proposition 36 is sufficiently specific, or if we should name the statute.
Probably both.
The actual sections,
The layperson probably knows it is Prop 36, but
Right.
yeah, it's probably good to have both.
By the way, I checked the Lazansky definition in the footnote. It is a paraphrase, so a C site there is appropriate.
So just so I'm clear, Jim, when you said that it might be too vague to say under Proposition 36 or other state law, if state law dismisses something, what would be vague about that?
I'm not a criminal lawyer, so I don't have welcome details. I'll just dig.
Okay, David?
Well, so there are, it's the 1203.4 versus 1203.4A issue, which is one of them, dismisses or seals the records for, and they don't
for
have to
licensing,
disclose them to
for
us
the
others,
licensing.
yeah. At least that's how that's been interpreted.
Well, you could say under Proposition 36 or similar statute that, that makes that clear, that permits, dismissal for, non-disclosure for licensing agencies.
Yeah,
or something.
or,
Yeah, it's good, that's what, or similar statute which permits non-disclosure to licensing agencies.
Yes.
That's good language.
It's a little tricky because technically there are statutes that name certain licensing agencies and not others.
We should say the state bar.
There are statutes in other jurisdictions. Well, this always is interesting to me, that there are statutes in other jurisdictions that provide that they say you have to disclose to the state bar, but they only name their own state bar. I'm sure it's a sort of a drafting oversight.
Right.
But in any case, it's still, if you're referring to us, it makes sense. Dismiss and expunge under Prop 36, or a similar statute that permits non-disclosure the State Bar of California, maybe. Or maybe the
should
State
be
Bar is
State
fine in
Bar.
this context, it's understood, just, you know.
Yeah.
And we're not setting a rule, we're just setting guidelines.
That's right, that's right.
So if we're adding in that language, do we still, then we don't need the reference to the out-of-state jurisdiction from the application, that language, for doing this instead?
Oh,
I think we do because it might be a statute from
Okay, so keep it out.
another,
Okay, so we'll add that in afterwards then.
or does similar statute capture, it could be California or in another jurisdiction?
actually, I think we need input from you folks because you're the ones that are going to read this with your staff and making the ultimate determination. Do you think it's clear enough?
Personally, I think the similar statute would cover the out-of-state as
Yeah.
well, but,
I think so
Okay.
too.
so we'll just add the statute then for Prop 36.
You're being quiet today.
I'm always happy to sit here quietly.
And then you're going to check and see if Prop 38 should be defined to a criminal code section or something.
Yeah.
We can do that one after.
Oh, okay. we
But maybe
can-
put in brackets, because again, people may know it as 38, because I know like Prop
Or
38 I
36.
deal with, and I couldn't tell you what the statute is.
Me too.
I think with that, since we know specifically what we're gonna insert, it's okay.
Yeah, good point. Yeah, some of those propositions have a lot of different statutes.
Meredith, can you see what we're doing, or are you just here?
I can hear you.
But have you got us on webcast or not?
I did not have that open.
Okay, that's fine, just curious. Thank you.
There's a little bit of a delay between the two, just an FYI.
30 seconds. Would you like me to email you the link, Meredith?
If it's on the webcast, I can just open that.
It is.
It may be helpful to you when we actually start voting.
It's not that we want you to see us, but the screen might help.
And if you can't, then we'll try to verbalize it.
Oh, I can see it now, thank you.
Okay, does anyone else have further comments on the decision matrix? Okay, I think all those conversations were good. My proposal is before we make any motions, we move to 2D, which is the discussion of the implementation. We kind of covered a lot of the implementation earlier, but I think it would help to finish that up and then go back to the voting unless someone has other ideas. On implementation, we talked about these will be passed out to schools, available on the website. Anybody else have any questions about how this is going to be made available? If you want to go through what happens next, this might be a good time to talk about that too. What's after we vote today? Where do we go from here?
So from here, what we'll do is we'll send it out to the Supreme Court, simply Mr. Gupta, for their feedback, as well as we'll send it out to the Committee of Bar Examiners, so that way they have time to review it before our April meeting. Hopefully at the April meeting, they will approve it, and then from there, it will move to the Board of Trustees for their review. And then once it's gone through and been approved by the appropriate groups, then staff will begin implementing it. So I think there are probably a couple documents internally we'll need to change, training-wise and whatnot, and then we'll get it worked on and posted on the website as well as available. We do have hard copies available for the application for applicants, so we'll also make sure that this information is available for any applicants requesting that information. For staff-wise, we have a combined meeting for moral character and pre-processing, so the folks that do the initial intake essentially of the applications in March. So at that point, we're planning on going over what the final products are. It's prior to the CBE meeting, but just so that way they can see it. Again, we've brought it up a couple times along the way, but we want them to see what the working group's final product is. And then once it's been approved again by the respective groups, we'll meet again with both moral character and pre-processing and go over the final work products.
Estimating this will be out, available public in the fall, October.
I think that's where our target was, so.
Okay, thank you.
Is it still gonna come to the CBE and?
April.
And I won't be there for that presentation, so Judge Terrio will be making that presentation.
So the main thing that drags this out is waiting for the court to sign off, correct?
Well-
It's like, why, if the
Has joined the conference.
CB is gonna approve in April, why does it take till the fall for it to be published?
This might be a Caroline question. So I think we've gone back and forth on whether the Board of Trustees actually needs to approve or not approve it, if it's more of just a receive and file or approving it. The Supreme Court, we're sending it to them just for input, so they don't actually have to approve it. But I think it's, because after the CBE approves it, then it does need to go to the board, one way or the other. It's just whether or not it's approval or review. So I think we've gone back and forth on that.
So was your question more as to the timeline, or?
Yeah, I'm just saying, you know, if we approve it in April, why does it have to wait till the fall? When you say fall, to me, that's September.
Is that based
And it
on?
might be nice to have this prepared, pushed out in the summer so that the law school, because the kids all enroll in the fall, right? I assume, I haven't been to college in 50 years, so the kid, you know, they all enroll in the fall, right? So this way, the administrators and the deans and all that, and all those folks get it during the summer, and they have, you know, some time to prepare it so that they're messaging properly to the students.
So the Board of Trustees meeting that we were aiming for is May. And then after that, I think we were trying to just give a little bit of a buffer for the whole design process in and of itself. And then we have, with the July bar exam, most staff is out, so I think that's where some of the timing came in. It may be sooner than that, but did Teresa or Louisa join? I heard somebody else jump on the call.
Yes, Teresa is on.
Thank you, Teresa. And so, just speaking to the timeline portion, in your experience, how long typically would the process of working with like the graphic designer take?
Well, I think that we do need to allow, you know, some weeks for that just because of the back and forth. And then in addition to graphic design, there's remediation. So it's hard to give you, you know, something that's super firm without having gotten started with the process and knowing, you know, where it fits in with other work. But it's not something that would take months. It would be weeks.
I agree with Larry's suggestion that it would be nice to have it ready for when student affairs do their orientations with the fall students, which in the case of, like, our law school would happen the end of August.
That's what I was gonna ask. Is that the same for you as well, Dean Clancy?
No, we don't have the same time restrictions, yet I agree with Larry's point. Most schools are set up such that they have fall entries, September entries, so it makes sense to try to get this done sooner.
Meredith, when do you do orientation?
Orientation is typically the second week of August. You hear me?
Yes.
Yes.
Thank you.
Okay.
Well, it's doable, they could do it in July or something.
Okay. So if we approve all these, we can include in our motion that we encourage the staff to get this out and to the schools before the end of July. That way they could have it till 1st of August. Okay, we can just make that recommendation.
Do our best.
Yeah. Okay, does anybody else in the committee have anything they want to talk about with respect to 2D, discussion of the implementation of these 3 documents?
Well, I guess since we have Teresa on from communications right now, one of the working group members, Larry, had a question. With a change like this, would you typically send out some sort of like news article? I know we have our social media and things like that, and we can put a banner on the website, but other external facing ways to get this out?
Well, we definitely have our social media channels, which are pretty robust, and there is also the channels of law school engagement, including the e-newsletter, which there's an issue that's timed to go out in June and another one timed to go out in September. So both of those would be chances to promote it to the law schools themselves. But we think that our LinkedIn and Twitter and Facebook channels, we have a lot of law student engagement, particularly on Twitter. So direct to the students, those are very good channels as well.
And do you do things like send press releases out to the legal newspapers and, all the typical kind of stuff that a PR department would do?
Yes, we could do a press release on this. There's no problem with that.
I mean, David and Tara, I would hope that you guys take credit for leading the nation on this. There's no other jurisdiction has put together a matrix like this. So you should, I would hope you would take credit for it and also help lead other jurisdictions to a similar place.
Yeah.
And so I don't know if that's like presenting at like ABA or, what is it, the NCBE, like conferences and stuff like that?
So I went to so there's the NCBE, there's also CBAA, which I'm not gonna get the acronym right at the moment, but essentially it's the bar administrators. So at that meeting, I brought up some of the changes that we had, and looking forward, so I think at those sessions, there's always like moral character related ones. They typically ask like what's going on in your jurisdiction, so always happy to share that.
Louisa Irapetian
has joined the conference.
Okay, one last thing on 2D. I just wanted to quickly, Debbie, you had the question about the moral turpitude footnote, and I found a quote from Glass In Re Glass, that addresses it. It says, contrary to the review department majority's view that Glass's burden was significantly lighter than it would be for an attorney seeking readmission because he was a first-time applicant, in many respects, the difference between admission and disciplinary proceedings is more apparent than real. Because both admission and disciplinary proceedings concern fitness to practice law as evidenced by acts of moral turpitude. This court routinely consults its disciplinary cases in deciding whether applicants for admission possess at the outset the requisite moral character. And so, yeah.
Thank you. Okay, one last time. Any further committee comments or discussions on 2D, the discussion on the implementation of these three documents? If there being none, I think this might be a good time to open up again to public comment and see if Mr. Wexler wants to make a short comment, probably limited to 3 minutes, but I would open it to you, sir, if you want to say something before we move on.
That's very kind of you. I wanted to commend staff for putting together a very coherent and well thought out matrix. I don't have any particular comments. I think what you produced will be very helpful for us directing, for attorneys representing applicants to direct our clients. So I want to thank you.
Thank you, sir. Anybody else who wants to make a public comment? Okay, having not heard any further public comments, I'm going to go back to committee. And my proposal at this point in time is we start considering motions. So let's, unless someone has objections, let's go back to the proposed best practices for law schools document. And Tara, if you can kind of put that on and show us the three changes that, or whatever changes that we put in. And Meredith, can you see this?
I can. It's a little fuzzy, but I've got my copy as well.
If you have questions, please feel free to ask.
Okay, so I can read them out if that makes it easier as well. So the first change was just the first bullet point under general information and guidance, just clarifying if it's adding the and then determination process to moral character. The second was Jim's suggestion of this repeatedly reminding students that it's their ability to become aware of, or it's their responsibility, to become aware of the moral character determination requirements, to read and understand the instructions, to update the application when changes occur, and to timely comply with all requests for further information. Sorry, Meredith, I can see the webcast a little behind. I'll give you a second to see where it's located.
What's that?
Oh, sorry, best practices.
And I believe this was Debbie's suggestion, now moving to providing information and documentation. And let me switch this a little bit.
Real quick, Tara, I'm sorry, and this may be unnecessary. I was just wondering if, Jim, in your comment, if it should qualify instructions and say, application instructions or something, or if maybe in the whole context of this, that's clear enough. I leave it to you. To read and understand.
The application instructions?
Well, I'm just sort of thinking out loud. What do you think?
Doesn't hurt.
Instructions for the moral character application.
I guess I like it broad because no matter where they're getting their instructions, they should read and understand them.
All right.
As lawyers, we get our instructions from lots of different places. Have to know them all. Okay, all right.
Okay, so we'll leave that? Okay. So the third change was under providing information and documentation. And the suggestion is, at the time the moral character application is submitted, applicants may submit supplemental narratives to provide additional information, such as the rehabilitative activities in which the applicant has engaged. I believe that was all we had, and then there's just a page break which we'll take out, but, so we have those three changes.
We'll run a spell check.
Yeah.
Are you looking for a motion?
Okay, so let's have a motion at this point in time. Yes, Debbie?
I make a motion to approve the best practices and talking points for law schools.
Is there a second?
I second.
Okay. Anybody want to discuss it further? All in favor? Aye. Any opposed? Thank you very much. Shall we move on to the second document then, the statement and guidelines?
So with this one, the first change was just in the first paragraph, first sentence, changing it from consistent and transparent to consistent with governing law. So on page 3 at the top, just changing extension application is not approved to submitted. On page 3 still, again, adding Jim's suggested language. So here, it is the applicant's responsibility to become aware of the moral character determination requirements, to read and understand the instructions, to update the application when changes occur, and to timely comply with all requests for further information. And so this is David's amended language for the criminal history section. So now it reads, there is no criminal act that disqualifies an applicant from receiving a positive moral character determination given a sufficient showing of rehabilitation. Where serious misconduct occurs, positive influences about the applicant's moral character are more difficult to draw, and negative character inferences are stronger and more reasonable. When there have been serious acts of moral turpitude, the applicant must demonstrate that he or she behaved in an exemplary fashion over a meaningful period of time.
I had been under the impression that we were going to still leave the last sentence from the prior paragraph. What was your intent, David?
Okay.
Oh, right. Yes. Yeah. Sorry. You see that, Debbie? The part about saying, and even some criminal acts like civil disobedience is not necessarily
Relevant.
Yeah, unless there's some additional.
Yeah.
So yeah, I think that remains in the spirit of what you were after.
Okay.
Thanks for catching
That's
that.
the end.
Okay, any more comments on that?
And then, so on page 6, for the unauthorized practice of law, just adding in appearing in court or other tribunals as a legal representative for others.
May I suggest that we modify it further? I don't think it should be as a legal representative for others, as I had proposed, but I'm suggesting now that we change it to posing as a legal representative for another. Because they'd actually be posing as a legal representative. They wouldn't really be a legal representative for another if they're not authorized to practice law.
Yeah,
So
posing or acting,
a word
maybe.
like it means acting is a better word.
Maybe acting. Yeah, we don't want all the pro pers of the world to think that we're.
Right. And rather than for others, it could be for another. It could be just one person.
Good point. Yep.
Those were the only changes to this document, so.
Is that proper English for another? Could be, my daughter to ask.
Acting as a legal
For another
representative
person.
for another.
Yeah, that's all
Oh,
right.
yeah.
Or how about,
Another
yeah.
person.
Another person.
Or
That's
entity?
better.
But then what about an entity too? I don't know. I don't want to be too nitpicky.
For someone other than oneself.
That sounds a little too,
Or how about, okay, acting as a legal representative for another party, for, or for a party
for a part.
other than oneself, something like that.
Just a minute. No lawyers here.
David, I think if we use the term party, then that's gonna throw up the, a possible understanding that that only applies to lawsuits, and when a person is not a party to the lawsuit, they could be a witness, but if somebody's appearing for a witness, that could still constitute practicing law.
Well, for representative other than oneself.
Yeah,
Yeah, that might be.
for someone other than themselves. What?
Yeah, someone other than themselves.
Wouldn't it have to be him or herself?
Oneself, themselves, which,
Him or herself, I like that better than themselves.
How about other than the applicant? It's neutral.
that works.
Yeah, that one, I wonder about that, because when you use the word applicant, it almost suggests that the situation involves an applicant rather than, for instance, a party plaintiff or a party defendant, so.
I'm fine with them oneself, himself or herself.
Either that or other than oneself.
That's good.
And there is a distinction between oneself as one word and oneself with apostrophe s as two words. Oneself is one word referring to something being done back to the subject.
What is the
Wait, acting is.
consensus?
Hold on one second. I think it's oneself, one word. I can hear all the grammar people out there yelling. The problem with their self is it doesn't agree.
So acting as a legal representative for someone else, is that grammatically?
Actually, I like that. I like that, even though, yeah,
I mean, it's a simple way to put it forward.
yeah.
Okay.
I like that.
It's plainer.
Plain.
Yep.
Hopefully it's proper.
Yeah, I mean, you can parse it to within an inch of
Yes.
its life, but I think that absolutely, accurately represents what we're trying to say.
Okay. So those are all our changes.
Okay, Meredith, any thoughts? I just check in
No, that looks-
occasionally.
Yeah, I'm following along and that looks good.
Okay, so do we want to have a motion at this point in time?
I make a motion that the determination statement and guidelines be accepted as modified.
Is there a second?
Second.
Debbie? Any discussion? All in favor?
Aye.
Aye. Any opposed? Thank you, Meredith. Okay, so that takes care of the second one. Moving on then to the decision matrix.
Okay. So on the first page, under conviction for drug sales or possession, so box 2, additional inquiry seldom needed, just adding the language, or a similar statute that permits non-disclosure to a state bar. In column 3, so parsing them out, so no drug sales, 1 or more convictions, possession, multiple convictions.
Were we gonna also make a change to the disclaimer?
I was
Oh,
thinking the same
yes.
thing.
And which, so I don't have your language here.
Oh.
Can you read it and
I
we
like
can
the
choose
second
which one?
language better, David, than included specifically for it, specifically. I think it. Right?
Oh.
Didn't you, it was gonna be the second sentence, right?
Yeah. I'm just gonna type it in.
Right, Gabe? The one that you read out loud?
Yeah. There were two. Am I thinking of the right, hold on one second.
This is the one that
This is
I was
just to
referring
like
to.
flag them that like it's based on.
Oh, yeah,
They're
so
limited by
the two
Supreme Court law.
choices, the two choices.
Yeah.
Yeah, so the first one was, the information in the matrix is consistent with decisional, statutory, and other relevant governing law. And the second one, which I think is the one you're talking about, is the matrix is intended to reflect standards set forth by the California Supreme Court and other governing law. And either way, I think it would be the second sentence of the entire.
Right. Just, is that the language the working group agrees upon? Figured too.
I think that language is fine.
Because there are, of course, some statutes.
Yep. Thank you.
You like it in the middle there?
Just because it follows we lead with, it reflects the methodology typically utilized by the state bar. So we were, I think the thought was to kind of quickly add, by the way, the state bar didn't just come out with these standards willy-nilly. That was my thought, but
Okay. Move on then.
So we're on page 2, under the mitigation, aggravation, and rehabilitation. So we're adding in rehabilitation related to factors that contributed to the offense. And on page 4, it now reads financial or emotional impact on victim. I think that's it.
Thank you. Does anyone want to bring a motion?
I move that we accept the decisional matrix as modified.
Is there a second? Thank you, Debbie. Any comments? Meredith, you still there?
There.
Okay. All in favor?
Aye.
Any opposed?
Aye.
Thank you. Hearing nothing, then all three motions are passed. Thank you. So, we only have one last item on our agenda. That's 2E, discussion of objectives and achievements of the Moral Character Working Group. And we have lunch set in a few minutes, so we can kind of cover that and be done. And if people want to stay for lunch, that's fine. If they don't, they can take off. I'll start. I am very happy with the way this turned out. I enjoyed working with you folks. I felt a lot of people had a lot of great things to say, and people were willing to say them, and we produced a great product. So I guess my first comment is thank you all for all your hard work. So that's my spiel. Anybody else want to say something?
I want to commend the staff. I think the staff's been amazing in terms of like the information you presented to us and how easy you made it for us to be able to provide feedback and think about the right things as we were contemplating this. So I really go State Bar.
Right back at you. We really appreciate all the hard work that the working group put into this. And, as far as the objectives and achievements, it might be worth just mentioning what the objectives were. And, I think our goal here was to provide more detailed information to law schools, law students, applicants, potential applicants who are even thinking about going to law school. More transparency and predictability, and generally pull back the curtain and let people know more about how this process works so that people aren't unnecessarily deterred from trying to become an attorney in California, and they also understand how to navigate the moral character process. And so hopefully we met those objectives.
Can I ask something about that? Like, is there a way to see, like, to begin? I know that going back, it's hard to go back and look at the files to see, how many applications you received and, how many people and for what reasons they were denied. Going forward, is there a way to, really kind of track maybe how this is working in real time?
It would, I'm not a statistician, but the variables involved, I think, would be difficult to tease out because there are several different variables. So there might be more people who decide to go to law school because they see that although they have a felony conviction, that's not an automatic disqualification in California. So maybe there are more applicants to law schools, but they may or may not become lawyers in California or even try. And so that number is a little elusive. And then there are people who go to law school and find the process easier to navigate because of the tools that we produced here. And there's no way to really capture that. You know what I mean? Mm-hmm. Are you thinking?
I'm just knowing that there is perhaps a misconception. You presented us data very early on how many denials there are in a given year. I think that does not align with what the perception is in the community about the denial rate. And so I'm just wondering if being transparent in the spirit of transparency, if that might also be something that you think about.
Well, that might be interesting.
How many applications you get in a year and how many are, how many go to informal conference or how many go to, how many get appealed to the CBE and then what the, just statistics like that make it more transparent to people about what the process is.
Even just that initial number, it would be something to see the number of applications go up dramatically. I don't know if that'll happen or not. Some of that information, and Tara could speak to this probably better than I, is captured but not
I'm thinking too, so currently right now with the committee of bar examiners, the director, so Amy will present key statistical factors, and one of those is like the number of applications itself. So we do have that historical record, and that could be a discussion possibly, I think, with Amy and the committee and OGC if we wanted to add some of those additional data points in, because that is an open session and that's public record, so.
I mean, because I was kind of surprised when, I mean, it was originally when I met with Mark, I think where he said it was, you know, a very small number, and then you presented data, I think it was like 50 or something like that are denied in a given year.
And I agree, because I think even when we go to the law schools, we see some students who have these fears for things that we consider, you know, relatively minor. So hopefully with these matrices now, it will help alleviate some of those, and they'll see that there is no bar and there's a pathway in regardless, so.
And remember, a denial means you can come back in, it depends on the circumstances, a year, 2 years, 3 years, and try again, and in that time, hopefully engage in sufficient rehabilitation. So even a denial is not the end.
Finite.
Yeah.
By the way, once these are turned into web pages, and I'm assuming that they will be, the moral character determinations, statements, and guideline, and then the matrix, the clicks on those pages can be tracked. I think it would be interesting to see how many people over a period of a year have clicked onto those pages. To what extent have people been curious about these issues? We'll find out by finding out how many click on those pages. I have to say that I'm excited about the prospect of having them available so that we can connect them to our website somewhere so that people can get information that they've been calling our school about for a very long time. And we've been spending a fair amount of time trying to answer the questions, and it's been somewhat difficult because there are many gray areas in all of it. So this will help a lot.
Yeah, I'm hoping they get enough traffic to, crash the server.
And so before we wrap up, I just also wanted to say thank you all for being so engaged. I mean, we wouldn't have these documents as well without all of your input, and having to put in that additional time, not other than the meetings, was really appreciated. So thank you.
Yes, I just want to say, I asked this item to be put on because I just wanted to ask the question, do people feel like we accomplished the goals and objectives we set out to accomplish? That's all. So apparently the answer is yes.
I think we did. I have to say, I really enjoyed my involvement with this group very much.
I'm more optimistic about working groups than I have been in the past. I was somewhat leery of the idea, but it certainly was a good one. Okay. So unless someone has something more, we'll break. We're done. You don't need to come back, but we have lunch available for anybody who wants to have lunch.
Can I just ask that you keep
Jack
us informed? Could you keep us informed
Has
of the
left the
process?
conference.
Like, so that if, I mean, none of them.
Yeah, as it
granular
gets
detail, but
approved
like,
and-
As
as
we
things
go
get
along.
approved or don't get approved, like, if you could just keep us informed.
Yeah,
so
that
we
should
know.
be fine, right?
Has left the conference.
Just updates to those.
Yeah, as long as it's from staff and.
Okay.
I don't know if we want to, I think our public commenter may have dropped off the call, but do you want to ask for public comment one more time before we go? Just because
Certainly
we
can't
said-
hurt. Okay. Before we close the meeting, we'll make one more call for public comment. Is there anyone in the public who wants to add anything further with respect to this moral character working group? Having heard nothing further, we'll close public comment and we'll close the meeting. And hopefully I'll see some of you again. Larry, I know I'll see you again. Staff, I know I'll see you again. Okay, thank you.
Thank you.
Thank you.